Before the legal chess match of the appeal could even begin, the Western Cape High Court found itself pausing to settle a critical question. Should the state's most controversial witness, Lourentia Lombaard, be shielded from prosecution for her role in the Joshlin Smith case? It was a question that would ignite debate over truth, loyalty, and the price of cooperation. Before we continue, I'd like to thank you for the subs, likes, shares, and comments. It really helps us, a small, self-funded media publication, in our mission to tell South African stories in a meaningful way. We'll be relaunching our audio-only podcasts, Crime Central South Africa and Season 2 of Unsolved Murders SA, with a thorough deep dive into cases that have not only gripped the nation, but still linger in the fabric of our society. Back to the video. The court day began with what Judge Nathan Erasmus called a quote-unquote housekeeping matter, but it quickly turned into the first flashpoint of the appeal proceedings. The complication arose from a legal mix-up. Advocate Eben van Tonder, who had previously been involved in the matter when Lombaard became a Section 204 witness, was no longer officially mandated to represent her. Legal aid had been instructed to remandate him, but van Tonder refused. That's when Erasmus, in a move that underscored the stakes, ordered van Tonder to take on the case pro bono. Duty-bound to the court, he agreed. And with that, the stage was set for him to make the case for Lombaard's immunity. For the viewers, here's what Section 204 means. Under South African law, a witness can be granted immunity from prosecution if they testify frankly and honestly about their role and the roles of others in a crime. In essence, it's a deal. Tell us everything truthfully, and you won't face charges yourself. But that protection only applies if the court is convinced the witness lived up to their side of the bargain. Van Tonder anchored his pitch on Section 204, subsection 2, stressing that if a witness has indeed answered honestly, the court must grant immunity. He painted a picture of a woman under extraordinary strain, the crushing spotlight of the media, the pressure of being the state's key witness in a trial that has gripped the nation, even moments of acute distress where she required emergency intervention during testimony. He reminded the court that Lombaard's version wasn't standing in isolation. Her account, he claimed, had been corroborated by independent witnesses. He pointed to Judge Erasmus's own earlier remarks about the state's quote-unquote mind map, a circumstantial web of evidence connecting Kelly Smith, Jacquen Appollis, and Steveno van Rhyn to Joshlin's disappearance. In van Tonder's view, the criteria were met. She testified under oath. She provided information that advanced the state's case. She and her family's lives were uprooted into witness protection, but Judge Erasmus was not prepared to let that go untested. He zeroed in on the contradictions between Lombaard's first statement in March 2024 and her latest statement in October 2024 after she had turned state witness. Why such a stark difference? Van Tonder's explanation was a window into the murky loyalties at play. In March 2024, Lombaard was still bound by a pact of silence with Kelly Smith, one that came with the promised 1,000 Rand payoff. She was also in the grip of heavy methamphetamine or tech use, clouding her judgment. By October, however, things had changed. She had cut contact with Kelly, was sober, and as Van Tonder put it, quote-unquote, gripped by guilt. This, he argued, explained why her October account was more forthcoming, even if it painted an entirely different picture of events. In the end, Erasmus chose not to rule immediately on the immunity application. Instead, he parked the matter to be decided after hearing the defense's arguments for leave to appeal. For now, the question of whether Lourentia Lombaard will walk away from this saga without facing charges of her own remains hanging, and the answer could have seismic consequences for how the case against the 3 convicted stands up under scrutiny. For the convicted, Kelly Smith, Jacquen Appollis, and Steveno van Rhyn, today was about dismantling the very foundation of those convictions. The defense came armed with claims of coerced confessions, flawed witness credibility, and judicial missteps, but these arguments now stand face to face with the trial record that once convinced the same court to let those confessions in. Advocate Fanny Harmse, representing Jacquen Appollis, opened with the heart of his appeal, the extracurrial statement. Jacquen's recorded confession from the 5th of March 2024 should never have been admitted into the main trial. His position today was that the court had erred in allowing it, arguing that the statement was not freely given but extracted through coercion. Harmse painted a picture of his client as a man physically compromised, pointing to the evidence of injuries and the claim that these were sustained while in police custody at Seaborder. He highlighted the testimony of a witness who apparently saw Jacquen the morning he was taken from a hotel to see Boeta without any visible bruises as proof that the injuries occurred after that point. But here's the problem for Harmse. The trial within a trial record tells a more complicated story. In week 5 of the main trial, the video of Jacquen's confession showed visible injuries, a swollen right eye, a bruised foot, and a limp. But the medical evidence from Dr. Nell could not conclusively link those injuries to torture. Nell acknowledged they existed, but could not confirm when or how they occurred. Testimony revealed that on the 4th of March 2024, the day before the confession, Jacquen and co-accused Steveno van Rhyn were left unsupervised together in a Boeta boardroom for hours. This gap, while irregular, also gave them the opportunity to align stories, potentially explaining why their separate statements shared such similar detail. Crucially, the court at the time considered these factors holistically, weighing them against the fact that Jacquen was read his rights, confirmed understanding, and proceeded with the recorded statement. Harmse's appeal today hinges on reframing that sequence as coercion rather than compliance, but the trial record contains prosecutorial confirmations that will be hard to overturn. Advocate Joshlin Smith for Steveno van Rhyn ran a parallel track to Harmse's strategy. She too attacked the credibility of the extracurricular statements, emphasizing her client's claims of assault, suffocation, and the notorious quote-unquote helicopter suspension method. In today's appeal hearing, she argued that the state had not proven trafficking or kidnapping beyond reasonable doubt, and that common purpose could not stand without proof of the main charge's elements. But again, in the trial within the trial, Steveno's second recorded statement taken by Captain Philip C. Gowe closely mirrored Jacquen's. Both men named Phumza Sikaka as the recipient of Joshlin. Both described a 20,000 Rand exchange allegedly negotiated by Kelly Smith. Mgaba's challenge today is that, during the trial, the medical examinations of Steveno, first by Dr. Nell, then by Dr. Zimri, noted only soft tissue injuries and healing abrasions. Neither doctor's evidence conclusively proved torture. And while police presence during Zimri's exam could have affected what Steveno disclosed, the court ultimately found these were not enough to invalidate the statement. The other thorn in Mgaba's side is the unsupervised boardroom time on the 4th of March. The trial court recognized that this opened the door for collusion, but it didn't interpret that as proof of fabrication, particularly given the consistency between the confessions and other circumstantial evidence from the state's case, including Lourentia Lombard's testimony. Both Harmse and Mgaba used part of today's argument to undermine Lourentia Lombaard. They portrayed her as a serial liar who shifted her account to protect herself, pointing to the contradictions between her March 2024 and October 2024 statements. But during the main trial, Judge Erasmus had already addressed this in the context of admissibility. In his earlier reasoning, he emphasized that the confessions were not dependent on Lombard's word alone. They were separate, direct statements from the accused given after rights were explained and recorded. By contrast, the appeal applications today try to tie the reliability of the confessions to Lombard's credibility, as if discrediting her would unravel them. That's a harder sell when the trial court had already accepted them as independent streams of evidence. The defense's arguments boils down to this. If the confessions fall, the convictions fall. The court erred by accepting those statements as voluntary, given the allegations of coercion, injury, and procedural irregularities. Lombard's shifting testimony and vested interest in her immunity deal tainted the state's case. But the trial record, the same one Erasmus presided over, contains enough procedural safeguards, corroborative overlaps, and medical ambiguity to give the state a strong counterpoint that while the accused were not perfect witnesses, and while the process had flaws, the legal threshold for admissibility was met. Tomorrow, Advocate Joshlin Smith will take the floor for Kelly Smith, and the court could rule on both the leave to appeal and Lombard's immunity. If the defense cannot shake the admissibility ruling, the appeal will likely face an uphill battle. When the Western Cape High Court reconvenes tomorrow, the spotlight will first return to Advocate Joshlin Smith, who will conclude her submissions for Steveno van Rhyn. She's expected to reinforce her core themes from today: the alleged coercion of her client's confession, the unreliability of the state's Section 204 witness Lourentia Lombaard, and the argument that the state failed to prove its trafficking and kidnapping case beyond a reasonable doubt. Once Mgaba closes, Advocate Steveno van Rhyn, representing Kelly Smith, will step up to deliver his submissions. Given his approach during the main trial, viewers can expect Steveno van Rhyn to go on the defensive against the credibility of Lombard, question the consistency of the state's circumstantial web, and argue that there's no direct evidence placing his client in the act of trafficking or kidnapping her daughter. after both sides have had their say, Judge Erasmus may be in a position to rule on two critical issues before the court. 1. Whether the three convicted, Smith, Appollis, and Van Rhyn, will be granted leave to appeal their convictions. And 2. Whether Lourentia Lombaard will be granted full immunity under Section 204 of the Criminal Procedure Act. Either decision could reshape the road ahead. If leave to appeal is granted, the convictions could be tested in a higher court, prolonging the legal battle. If immunity is granted, Lombaard's position as a witness is solidified, but so is the controversy surrounding her testimony. While legal teams argue over past evidence inside the court, police are acting on new information outside it. This past week, the Western Cape SAPS confirmed they've returned to Saldanha Bay, the very community where Joshlin vanished on the 19th of February 2024, to conduct fresh searches in the Middelpos informal settlement. The renewed operation, involving K9 units, search and rescue teams, and local officers, was sparked by unconfirmed leads that investigators say they've not yet tested. Brigadier Novella Potelwa at the time stressed that the case remains open because Joshlin herself has never been found. The SAPS, she said, is obligated to follow every viable lead. And there's a thread of hope running through this new effort, one that comes from the state's own camp. Prosecutor Zelda Swanepoel, speaking at a National Freedom Network webinar, said she believes Joshlin may still be alive. Her view is grounded in the results of previous forensic searches where bones and clothing recovered from the dunes around Saldanha yielded no positive DNA matches to Joshlin. For the families involved, tomorrow's session is more than procedural. For the convicted trio, it could mean the difference between life sentences standing as final or being sent back into the uncertainty of appeal. For Lourentia Lombaard, it could mean walking away immune from prosecution or facing the prospect of charges herself. For investigators, it could mark the start of a new chapter if the ongoing search produces tangible evidence. And for the public, tomorrow is another moment in a story that refuses to fade. A case that has already delivered shocking revelations, bruising courtroom battles, and unanswered questions about what really happened to Joshlin Smith. As the sun rises on the next day of hearings, the legal fight and the physical search for Joshlin will be running in parallel. One inside the High Court's walls, chasing justice for a conviction. The other on the dusty streets of Middelpos, chasing a child who, even now, might still be found. This brings us to the end of our breakdown. If you made it this far in the video, thank you for watching. If you found this breakdown informative, subscribe and turn on post notifications. Remember, we have more content planned, more cases to unpack and true crime stories to dive into. So believe me when I tell you, subscribing to our channel and turning on those post notifications is absolutely necessary. Also, visit our news website, swisherpost.co.za, for the best explainers on every important event happening around you. No agenda, just the story.